Hi, everybody.
Hey.
Curtis and I are wearing our necklaces that were given to us by our Cameroonian Diversity Visa 2020 clients that recently arrived in the United States. So they said that this will give us power, so we're wearing these today. And thank you guys for giving us these gifts. We are greatly appreciative. It's been a blessing to help you guys with your journey here to the United States, and we're happy you guys have all arrived.
Great, thanks. Okay, so Rafael, do you want to go off the questions that were stray questions on Facebook, or do you want to go off the ones that are in the comments now?
We can go off of, we can start with one of the questions on the, that were provided beforehand.
Okay.
So the first one says, hello, dear Morrison. Fortunately, you have posted something about getting notified when you will announce DV 2021 lawsuit. The problem is when I was going to fill out the file, in the country section, Iraq name doesn't exist. Can Iraqi citizens participate in your next case? Yes, every nationality will be able to participate in our next case. That was an issue we had with our first sign-up form. That issue has now been resolved. If you go to our websites and our Twitters feeds, we have links for those new sign-up sheets. Wait list for the case. We'll provide that after the question and answer today, again, for people to go and sign up. And we anticipate from today's TravelGov YouTube Live Chat with Charlie that all diversity visa numbers will be current in the July Visa Bulletin, and that will be published in the June Visa Bulletin. So everybody will be able to participate in that lawsuit if they so desire for DV 2021. So look out for that link after the Q&A and sign up for the wait list, and then that will start giving you guys information on how to sign up for the next case.
Okay, I'll do the next one. From Ahmad, you are doing a nice job. Can you inform us how you process the job for family-based visa applicant? Every time I see that family applicant issue isn't focused in front of the judge. So Ahmad's talking about the Jacob case. And he's basically trying to find out why we are talking about the DV selectees in the Jacob hearings, what he thinks is more than we were talking about the family preference categories. Rafael and I would say that we are not. It seems like that if you are an individual F2A or an individual F1 or F4, and so you're not hearing those terms. The term that we're using is family preference categories, and we are talking about the separated families. Rafael, look back through the transcripts. What did you see when you looked at the transcripts from the hearings?
Yes, on the March 4th hearing, which was a big hearing in the Jacob case, diversity, the word diversity was mentioned 32 times. The word family was mentioned 31 times. So we are talking about both diversity visas and family preference categories equally. They're getting both types of visas are getting the same amount of airtime before the judge. Now, Judge Chen isn't an immigration attorney. He doesn't spend his entire day parsing out immigrant visa categories. So when we speak, if we were to say F2A to Judge Chen, he wouldn't quite understand what F2A is, but he does understand what a family preference category is, and he does understand what family separation is, and these are the most important things for the family-based visa applicants. So the, I guess, critique of the Jacob case that the F2A category isn't getting enough attention as the diversity visa is not reflected in the transcript that we have reviewed. We took your criticism and we reviewed the transcript, and what we found out is that they were getting equal footing before the judge. Diversity visa was mentioned 32 times, family preference category was mentioned 31 times. So that's pretty even. I don't think we could have done it any better than that.
I would also add that oral arguments before the judge are about what the judge wants to know about, and we're answering his questions. If you really wanted to make that argument, you could go back through the briefings and see. But here's the thing. There's no correlation between the relief you get and how many times we say that. It's not, repetition is not the only thing that's going to win the day. Solid legal arguments. So if we've already made solid legal arguments on something and the judge already agrees with it, there's no reason for us to talk about that anymore. Just repeating it would be like annoying to the judge, right? Okay. You want to do the next one?
And at the next hearing, family preference categories and diversity visas are going to be equally before the judge. Those numbers are going to have to be parsed out in the status report to the judge by the government. So he's going to be able to see all those different categories and the pace of adjudication for those categories at the next hearing. So we'll be able to discuss each of those categories individually if the judge so desires, and the pace of adjudication there. So look out for that at the next hearing.
Okay. So going back to the list, Rafik says, I'm a winner of DV 2021. My case number is 40,000. I've not received an email to send the documents. Visa bulletin is current. Can I join the lawsuit? And if it wins, will I be eligible for an interview because I haven't received an email to send the documents yet? Okay, first of all, we have two DV 2021 cases right now. We have Jacob and we have Ray. We're not adding plaintiffs on either one of those cases because that would slow down the relief for the existing plaintiffs, and we don't do that. So you will need to wait to the next DV 2021 lawsuit, which we will file. We are going to file another lawsuit. We are going to make an announcement about that next lawsuit on May 1st to the people who have signed up for the wait list. And you can find the wait list everywhere you can find my name.
We have a question here. Let me see. Do I need a lawyer on this case? I won the diversity visa 2021 and I sent my DS-260 7 months ago, but no response. The problem is I won the diversity visa 2018 and I was refused under Proclamation 9645, which is the Muslim ban, and I wrote this on my DS-260. Do you think they ignore my case because I was refused, or they're going to process my DS-260? I think the problem is systemic. It's not something that's related to your individual application. Do you need a lawyer? No, you do not need a lawyer. Do we suggest you have an attorney? I would suggest that you have an attorney to bring your claims before court, because the processing of diversity visas is absolutely zero. We need to address this before the court to get a court order to either preserve the visas or have those visa applications processed before the statutory deadline for diversity visas. So do you need a lawyer? No. Is it in your best interest to obtain attorneys and to bring your claims before federal court? Yes.
Great. Okay, here's we're almost through we're halfway through the questions that we had that were going into this. So we'll go in and get through those, and then we'll get to the ones that are in the comments. I am a F4 derivative applicant, and I'm on F1 visa in the US, student visa. My priority date's been current for a year. I have a debt of almost $700,000 in student loans. Oh my goodness. And home mortgage. Can I request an expedite on the case to maintain my visa so that I can take care of the financial burden? You could. It's very unlikely that will work. The bar is high for an expedite right now. The State Department, through their visa office, has created a bar that is so high that most people cannot get it. They've actually told us, NVC told us in an email, that the bar is a life or death situation. So typical like economic problems like this, challenges, gosh, that's a high student loan, are challenges with like, I'm depressed. Believe me, I think that should carry weight, but it doesn't. They are only granting the expedite request for people that have really emergency situations from their perspective.
We have a question here that says, Mr. Morrison, what do you expect to happen after our hearing on the 20th of May for Diversity 2021 in the Jacob case? What I anticipate to happen is that we're going to have a discussion about the pace of adjudication. The pace of adjudication, from what we can see in diversity visas, are nominal, right? They're nearly zero. 17 or 20 diversity visas were issued in May. He's going to have some concern about that. We are also going to have a conversation about the pace of adjudication for F2A and family preference categories, and what happens after that hearing, I cannot tell yet. We're going to have to see the tone of Judge Chen and what he anticipates to do. So we're uncertain what's going to happen after that hearing, but what we do know is that we're going to have a conversation about the pace of adjudication. And the pace of adjudication is really what everybody is concerned about, what every Jacob plaintiff is concerned about. They want to see a pickup in the pace of adjudication of their individual case, right? They want to have their case adjudicated. So what happens after that, we're uncertain, and it would just be us guessing at this point. We'll have a firm answer for you on that question after that hearing.
Okay, I've got one from Ashraf that's DV 2020 winner, and he says the expectations required for DV 2020 winners is an increase in the number of visas. The end of April or May is not as important as the number of visas. It is expected to increase the number beyond 9095, the 9095 visas is the question. I understand exactly where Ashraf is coming from. He is right. The more visas that are available, the more everyone's chances are of them being issued. However, this is not a decision that I get to make, or Mr. Cook or anyone else that's talking about this gets to make. It's a decision that Judge Mehta gets to make. I don't want to make arguments on behalf of the government of why this shouldn't happen. I think that there's reasons in equity on why it should. You need to just be patient and see what Judge Mehta decides to do. Hopefully he increases the number beyond 9095, but you need to be patient and see what he needs to do. You did not hire us. A lot of people, you hired us to solve the problem. You didn't hire us to predict the future. That's not what we do. We don't have crystal balls. Have to wait and see what the judge does. Rafael?
Yes.
You have one?
Okay, so yeah, I have a question here. Sorry, just lost it.
I can take one if you want.
Yeah, sure. I lost my place,
okay.
I'm sorry.
Ferdo's asked, I need your help. I'm a lottery winner from Afghanistan. I submitted DS-260 form in June, but unfortunately didn't receive email from KCC for submitting my documents, and no one is current for interview at the Afghanistan. Actually, this is an old question because now everyone is current in Afghanistan. What should I do? Should I send my documents to KCC or no? I get this question a lot. I know some, the KCC directions are do not send the documents until we ask for them. But other people have sent them, and there's never been any negative consequences. If you want to send your documents early, I think the only risk to you in sending the documents before they're requested is that you will have to do it again. Not the end of the world. Just follow the instructions when you send them. Name your documents correctly.
I have a question here. It's regarding DV 2020. Any news from Judge Mehta and on the final decision regarding Diversity Visa 2020? No, we haven't had any new news since our briefing schedule. Judge Mehta hasn't scheduled a hearing on the motion for summary judgment. It may be that he doesn't feel the need to have oral arguments. He is very well versed on the subject. We had an extensive preliminary injunction hearing that lasted almost 4 hours, which is extremely large amount of time devoted to the subject. He wrote an 80-page decision, which is very long for a decision, an opinion. So he not only did he hear oral arguments for a long time, he opined or wrote about the subject for almost 80 pages in depth. Then after that 80-page decision, he issued 3 more decisions on the case. So he has revisited the subject frequently. And then there was hundreds of pages of briefing from Gomez, Aker, Mohammed, Fanjong, and Kennedy plaintiffs on the topic. And he may not need to hear any more oral arguments on the subject. So we have no news, but I anticipate that we will get some news shortly. Exactly when, I don't know, but I think Judge Mehta understands that people's lives are in limbo. He discussed that in his first order, and he will issue a decision as soon as he can.
Okay, I think, Rafael, we've finished all the questions that we were sent beforehand, right?
Correct.
That's what I'm showing. Okay, so now we'll focus on the ones in the comments, and I'll try to get the earliest ones first, although my feed is a little confusing. It doesn't scroll all the way back up to the beginning because there's so many comments. And then they move. What is your expectations for the May 20th hearing? Rafael already answered that. I would add one little thing he may have said and I might have missed. This could go two different ways. The government could show reports that reveal that they are not adjudicating visas, which is the case, and at which time they're in a really bad situation and we will probably get relief. The other way it could go is the government could react to the requirement and actually start adjudicating visas. That is great because visas is the goal. If they are compelled to act in order to avoid their homework looking awful, that's great. And actually there's precedent for that. Remember, Judge Chin originally told them that he was moving the, he set that status conference for March 4th and said, let's wait and see whether the government gets rid of PP 10014, and the government got rid of PP 10014. So there is precedent for the government reacting to Judge Chin to avoid consequences of not pleasing him. So let's hope that that's what happens too. So there's two different things that could happen on May 20th.
And
you want to go?
Not only is there precedent for the government to do that before Judge Chin, we saw them do that before Judge Chutkin in the Ray case, right? We brought a case challenging the regional proclamations, the COVID-19 proclamations that were suspending immigration to the United States. And shortly after we filed that lawsuit, shortly before the hearing, they rescinded that and said, issued a national interest exemption for immigrants to the United States. Whether that applies to individuals is yet to be seen, but there was some movement on that subject. So we know just by bringing forth the claims to federal courts, we get action from the government. And so bringing claims to court sometimes gets you results without having to get an order from the judge.
Hussein asked a great question. Can you ask Judge Chin for the relief to be remote interview that for the people that are DQ'd? Why is that a relief? Why isn't that a relief that we can ask for? Hussein, you are being logical, and we have to make arguments that are bound by the law. There's not a legal precedent for, Rafael, you need to move away from the airport. Okay, there's not a legal precedent for these planes distract me. There's not a legal precedent for a judge ordering the State Department how to do its job. There is for them to order the State Department to do this job, to do the job, right? But when you're talking about like a policy or practice that is like ingrained in how they've done it, they've always done it with in-person interviews for immigrants. It's going to be difficult to change that, and it's not going to be from a judge. So we have to focus on what's most viable.
And what's happening there is the State Department is interpreting a regulation that says immigrant visa applicants have to appear before a consular officer for the adjudication of their visa application. They have interpreted that language, appear before a consular officer, to mean the personal appearance. Now, the law may or may not give that interpretation deference, but that's the interpretation that they have now. Now, this subject of remote appearances or video appearances before a consular officer has already been broached with the administration. They haven't adopted it yet, and it's yet to be seen whether they adopt it. Now, this is some things we can discuss with Judge Chen if we get to the subject of relief. He hasn't gotten that far with us on just the appearances, not relief in general. We have had discussions of relief in general, but what the interviews themselves looks like. So it's a difficult topic. We're aware of it, remote interviews. We just haven't had the opportunity to discuss that directly with Judge Chen. Okay.
Okay.
Yeah.
I saw this. What about DV 2020? Let me just give an overview of that, because I know a lot of people are watching their DV 2020 to say, hey, have we got a judgment yet? We don't have a final judgment yet. We actually don't have a hearing yet. Now, he doesn't have to set Judge Mehta for the Gomez and Mohammed Fong John Kennedy Acre consolidated cases. He does not have to set a hearing. He only sets a hearing if he has questions. It's likely that he will set a hearing. Before, I had predicted, and I was hopeful, that we would have a final judgment by the end of April. With each passing day, that looks less likely. I think it is now going to be May. But I'm not going to predict a day anymore, because let's just wait and see when it happens. It's getting close.
Okay, I've been seeing a question often. What is the benefit of all the cases being current at the same time? Is this good or bad news? If you have a high number, I guess it could be considered good news. So you're current, you are eligible to get an interview. If you have a low number, it could be that it's not beneficial for you because you have all of these individuals who are currently eligible for interviews. But what is clear from everybody is that being current means nothing if you haven't been determined to be documentarily qualified. And this seems to be the bottleneck right now. So if you're that KCC is really the bottleneck for diversity visas applicants. They haven't been determined to be documentarily qualified yet, so they can't even be scheduled for an interview. All this currentness means really nothing for anybody until you become documentarily qualified. So how this plays out in the court of law and before a judge is yet to be seen. But we know there's going to be some confusion, to put it lightly, on the processing of cases now that everybody is going to be current in July.
That's good. Sonia tracked down the first questions that are been scrolled up, so I'm going to go from those. I didn't know if you got that in email, Rafael.
Oh,
So,
I'll look it up right now.
Yeah, so I'm going to take the first one. From Maman. I'm a Jacob v. Biden plaintiff, and my visa type is F2A. I've always listened to the hearings. The embassy in Sudan does not schedule interviews. My case was DQ on May 2020. They refused my 2 expedite requests. Very, very common for that to happen, even though they had a good reason. How are you going to let the government, the judge, know that the government is lying, and you represent us on the best way, because the last hearing, the judge was concerned with only DV only, and what you think is the outcome of the case. Okay, because the judge is asking questions about DV does not mean he's concerned with them only. It means that he only has questions about them. Maybe he already has opinions about the family preference categories. That's the first thing. Second thing, Sudan is a problem. The way we're going to let the judge know is we don't have to. The judge figured this out. He's asking the government he's putting the burden on them to prove that they're not lying, essentially, by providing 2 reports that show that they have resumed processing and adjudication of visas. If their reports do not show, if their reports reflect what's happening, they've got some explaining to do. We don't need to prove that they're lying when they have to produce reports to show what they're saying is the truth, because the numbers don't lie. The reports will show. And if they try to manipulate the numbers and make them seem like something is happening when nothing is happening, we're going to respond to that and explain it to the judge. Okay, but we just have to wait and see what the reports say. I think one of them is due soon, right? Within a week?
Right. It appears that okay, so we got the March visa issuance statistics yesterday, and our team has been doing some rough calculations about the March visa issuance statistics. So we know in March, family preference categories that were previously banned were issued. We know that. What does that mean? And then, but we also know from our clients and the immigrant population, the immigrant visa applicant population, that they're not getting scheduled for interviews. So what does that mean? That may mean that we had some individuals that were in 221G administrative processing that were just simply adjudicated without the appearance of the applicant before the consular officer. So the consular officers may have just been able to issue those visas without scheduling them for interviews. This really for us doesn't mean anything because they should have been doing that all along. 221G was something that could have been adjudicated from the very beginning. But we'll be able to parse that out with the multiple reports, whether the March visa issuance statistics were 2,600 family preference categories were issued was simply an anomaly because of the 221G holdovers, or if this is a maintained steady flow of scheduling of interviews. We'll see if that's the case. Either way, only 2,500 family preference categories is simply not enough. It doesn't match the pace of adjudication for IR1s and IR2s, which is really what Judge Chen, I think, wants to see. So we'll be able to parse that out with him to see whether it's just 221G holdovers by the multiple reports, if it's the pace of adjudication is maintained. These are some things that we'll be able to discuss with Judge Chen on the next hearing.
Great.
And I want to talk a little bit to the Jacob plaintiffs about the next hearing. It's going to be very, very important that we use our time wisely before the next hearing. So if you don't hear F2A or F4 or the Mumbai embassy or the Manila embassy or Moscow embassy directly, it's because Judge Chen has already warned us that he wants to spend a limited amount of time discussing the numbers. He's given us plenty of airtime to discuss the broad topics already. He just wants to discuss the numbers. So we're going to be very direct in our next hearing and discuss exactly what he wants to hear about. We're not going to waste our time before the judge discussing things he doesn't want to talk about.
Okay. Shuza asked, and I see where other people have asked this too, can you sue a consulate for negligence delaying a visa? Okay. The thing is, it's our experience that the delays with the visa issuances and processing, it's extremely rare for it to be the responsibility of the consulate. I know when you're a foreign national and you're in this country and that building is there, that's where you think the delay is happening. But in most cases, the delay is happening with decisions that are made in Washington, D.C. at the visa office by people like Edward Ramatowski, who we have made a defendant in the Ray case. These are the people that are responsible for the decision. So you don't want to sue the consular officers or the chief consulate. You don't want to sue them because they are just following orders, right? There's a diplomacy strong framework that has been developed in Washington, D.C., and they're following that. So we always target where the cause of the problem is, and it's usually not on the ground of the consulate. Although there's a couple consulates we are keeping an eye on, Tashkent. So as far as the question, negligence is a tort. It's a different kind of cause of action where you're seeking damages like money damages, and it's difficult to prove, and that's just really not what we want. So we can sue the State Department for unreasonable delay. That's usually what we do. And under the Administrative Protection and Administrative Procedures Act and the Mandamus Act, we have causes of action where we can do that, and we do it regularly.
Okay, I want to discuss Project Voyager. I've seen some questions about Project Voyager. We have had movement on Project Voyager. We recently saw language out of Representative Chu's, I believe, office, and that language, if that bill were to be passed, would recapture lost diversity visa 2020 visas. It would recapture some other immigrant visa categories and other diversity visa years that were lost due to the Muslim ban and the Africa ban would be recaptured. It's a pretty broad language, and it's likely to pass the House if that language were to be introduced onto the floor. But our focus would be in the Senate, and our lobbyist, Bruce Morrison, has been working hard to get some backing for that in the Senate to make sure that it would be able to pass the Senate and get to the desk of President Biden, who would need to sign that into law. But there has been movement. It's a great improvement to see that that language has been drafted, that representatives in the Congress are looking at that language and are actively trying to get that passed. So Project Voyager, it has been a long journey, but it seems to be going well. Just having that language drafted and being reviewed by our representatives here in the United States is good progress. So Project Voyager is moving along.
I'll add a footnote to that. Project Voyager was 2 parts. The lobbying was 1 part. Project Voyager participants allowed us to finance the lobbying. The other part is we will represent Project Voyager clients in consular processing. That means we will try to get your interview scheduled even after Judge Mehta's order, okay? So we're going to take care of the Mohammed and Fong Jong plaintiffs that were not issued visas. There's some of them, and then our Kennedy plaintiffs, majority of them were not issued visas in September, and then Project Voyager clients, and we're going to, our focus after Judge Mehta's order, our team will be attempting to schedule interviews for them and remove any obstacles that you have and help you, because I know a lot of you have like questions about transfers and stuff like that. If you're DV 2020, you need to wait on the transfer questions until after the final judgment, because there's nothing you can do right now anyway.
That's right. But in anticipation of moving quickly and to ensure a likelihood of success of getting the immigrant visa, Curtis and I have hired numerous individuals, I believe at least 5 of them devoted to diversity visa and consular processing teams, and they will be able to assist you quickly and answer your questions and move as quickly as possible to get your immigrant visa issued. So we have devoted an entire wing of our virtual office to that happening.
Alice Batania asked, hello, Curtis, what are your plans if Jacob was dismissed without prejudice? Don't tell me that is an extremely unlikely event. Okay, I will not say that that's an extremely unlikely event, but it is, okay? That Jacob would be dismissed on May 20th. I don't foresee that happening, but I
agree. It's not going to be dismissed on May 20th. Not at all.
Yeah, because there's, as long as you all need visas, there's claims. So if Jacob was dismissed without prejudice, I'm going to answer this hypothetical question anyway. That means without prejudice means that you can bring other claims. So we're going to offer an opportunity or figure out something we can do to help the Jacob plaintiffs to move them forward, because with the majority of you, you realize we don't get paid most of what you're paying us unless you enter the country. So we're going to keep with you, okay? We're going to help you until, as long as it's viable that we can fight for you, we are going to continue fighting for you. I think some of you think that we abandoned people, and if you look back at our past cases and clients, that's just not been the case. If you go to our website and look at some of these cases like Darchini and Puzish, I mean, we stuck with them for a couple years until everyone got a visa that could viably get a visa.
That's right. And you got to see that not only our efforts to get Jacob participants visas, it's not solely in the district court. We've been pretty active on the consular processing side with expedite requests, communications with the embassy to try to get people interviews. So our efforts have been varied and not only dependent on Judge Chen and his order.
Fun fact about that, Ms. Robinson, who represents President Biden and Secretary Blinken on the Jacob case, with regularity, we let her know about specific, like really hardship cases and ask her, hey, can you relay this to your client? Are you really okay keeping all these doctors and nurses out of the US during a pandemic? Are you really wanting to keep this child with just realized I don't know how to say that word. This sick child away from his parents. And what we found is that's not effective, except in rare circumstances. It's been, it's odd that the government attorney and the State Department are not working together to try to mitigate the most compelling hardship in the case. If I represented the government, I would do that, but they don't seem interested.
Ahmed asks, why can Jacob plaintiffs not join the new lawsuit, as we cannot guarantee the judge's relief for diversity visa? The reason is a rule of law that you can't bring the same claim in multiple courts. This would be forum shopping. If we were to do that, or if individuals were allowed to do that, they would essentially take a claim to court, realize they didn't get a judge they wanted, and could be able to bring that same claim before another judge. This risks differing opinions and orders in various courts, and our rule of law doesn't allow that. So you can't bring the same claim before multiple judges. You can bring different claims before multiple judges, but not the same claim. So that's why you're not allowed to do that.
Right. Hussein asked, I'm rejected due to PP 9645, commonly known as the Muslim ban. Could you please recommend to me what should I do? Actually, it depends upon your visa type and category. If it was a family-based category and your attorney needs to get back with the consulate or NVC and say, okay, it's time to schedule the interview because 9645 is gone. If you are DV 27 to 2019, it's likely over, but there are still people that are advocating for you anyway. I think that I don't want to give false hope there. If you're DV 2020 and you refuse before under 9645, you need to wait till Judge Mehta's order. I think that covered all the categories.
Right, and if you were a previous diversity visa applicant that was refused under proclamation, follow Representative Chu. She's advocating on the behalf of recapturing those visas. So look to Congress to provide relief. And I think that's really the only place it's going to come from at this point, is from passing a law that allows that group of visa applicants to enter the United States. So you really have to watch what's going on in Congress and be on the lookout of that. Attorneys who tell you that they can really do something for those individuals. Well, let's just say it like this. I do not agree that an attorney will be able to bring a claim before the court for individuals affected by the proclamation for diversity visa applicants that will be effective.
Yeah.
And Curtis has been pretty vocal about that. Yeah, so.
Right. I mean, I do think it was unfair what was done. I just think that I think Congress needs to fix it, and I don't think that there's political will there for that, and it's frustrating. I understand. So, okay, Irvis asked, it's a Kennedy plaintiff. My family is going to grow with one other member this month. Congratulations. Hopefully, we're going to have a good decision from Judge Mehta. What should I do next? Okay, say you are having a baby. You're a DV family and you're having a baby. There's two different procedures depending on when the baby is born. If the baby is born before the interview, you need to get that baby a passport as soon as possible and get that baby added to the DS-260 before the mother attends the interview, okay? If the baby is born after the interview but before you travel, there's a procedure that you can do that the consulate can help you with. If you're our client, if you're Kennedy client, we will help you with. But right now, there's nothing you can do as a Kennedy plaintiff because you're DV 2020 and they don't talk to DV 2020s right now, okay? But I hope everything goes well, and we will help you with the baby situation once we know Judge Mehta's order and whether the baby was born before the interview or after the interview.
Okay, so I have a question here. Can you and Rafael lobby Congress to extend September 30th for Diversity Visa 2021. Congress is slow. Our government is very, very slow in getting things done. We don't have that much time. We need to go directly to individuals that have the authority to unanimously fix that issue, and that individual is a judge before a federal court. So we're going to focus our efforts on that, and with Diversity Visa 2021. We will not be, at this time, it may change, lobbying Congress to extend Diversity Visa 2021 deadline.
Manuel Flay Che asked, I filled out the form for the wait list. My question is, will this lawsuit help DV 2021 from Liberia get his or her interview before September 30th? Thank you for asking that question, Manuel. That is the purpose of our next DV 2021 lawsuit, would be to get the interview appointment before September 30th and to get the visa issued. Also, if it turns out that the State Department isn't issuing 55,000 visas before September 30th, we will make efforts in that same litigation, just as we will also in the Jacob and Ray cases, to get visas carried over like we did successfully last year in the Gomez, Mohammed, Fong, John Kennedy, and Aker cases.
Okay, someone's being pretty persistent with this question. Did Judge Chen give any attention to IR5 being an immediate relative category, but not being prioritized like other immediate relative categories? Judge Chen is going to give attention to all the visa categories because that's what he's asked. He's asked them to parse out the visa issuance statistics, so he'll give attention to the IR5 category. And we'll hear that at the next hearing. There's a question here. Why does the president or Congress doesn't do something and find solution for us? I don't know. We're asking the same question. We have to go to them to ask, and we ask it every day. I'm pretty hard on the president, Joe Biden. You can, if you look at my Twitter feed, I criticize him almost every day and his efforts to provide relief for the green card backlog and diversity visas. And I've been pushing hard every day. And Curtis and I are on the same page why they haven't provided relief for us so far. It gives us no pleasure to see the pain of the green card backlog or the diversity visa applicants and the situation. So we ask the same question of our president and our congressmen and women.
Helen Jacob asked, and it's been a few minutes ago, can I join the next lawsuit for DV 2021, even though the KCC has not processed any of my documents? I sent all the documents several months ago with them being requested and have never heard anything back from KCC. The answer is yes. And I want to say a footnote about that. There was a declaration filed in one of our cases, Jacob, from the director, Morgan Miles of KCC, where he was so vague as to how much work was being done by KCC. It makes me wonder if he's even really working there. He said, oh, we've done about 10,000. We processed about 10,000, and we're going to try to process about 20,000. And I'm thinking, don't you have a computer that tells you how many you processed, that you have to like estimate it within 10,000, right? So the reason I tell that story is I want you to understand part of the no visa policy that was put into place by Trump that Biden has adopted shut down the whole thing, not just of the consulate, but all the way from the KCC. And so the fact that your documents haven't been processed is one of the reasons we're suing, okay? There are all these little choke holds, decision points all the way through here that where people have different delays, but they're all part of the no visa policy that was put into effect by Trump.
I have a question here. My name is Mike. I'm from France. My case is current since January, and all documents have been approved by KCC in March. No interview yet. It is interesting for me to join the new lawsuit. What can I expect? Being prioritized for an interview if it happens one day? Thanks and take care. Well, we certainly will push for our clients to be prioritized. That'll be a claim that individuals themselves be scheduled expeditiously for interviews. So that would be what you expect from our lawsuit. If you have, even if you have had considered documentarily qualified. We're going to push for individuals that have had their documents adjudicated to be scheduled expeditiously for interviews. And being part of lawsuit may make that happen much quicker, even without an order from a judge.
Natasha Hagen, you've asked a very specific question. You may want to email me because I know you're our client. The Department of State has issued a level 4 travel advisory for Austria due to COVID. Are DV 2020 winners with visas that have been reissued before September 2020 still able, with an NIE, directly from the Schengen area to the US until August? Actually, not all of you until August. The way it reads, it's a little peculiar, but that national interest exception, what it does is it you take that national interest exception plus what Judge Mehta's relief said. Judge Mehta's relief is the original validity of your first visa. So you find out how many days that is, and then you add that to Judge Mehta's order. So I don't know if it's August. It could be. I don't know. But my advice is to get in the U.S. as soon as possible, because you are not a lawful permanent resident of the United States until you do, and you don't have those rights that come with that. So I know some DV 2020 winners who were issued visas are waiting for some very compelling reasons, but the sooner you enter the U.S., the better I'll be able to sleep.
I have another persistent question asker. I was going to answer your question. You don't have to post it here 20 times, but in this unprecedented COVID time, Abush, what special lessons you have learned from those past DV-related lawsuits? Well, what we have learned, it's not so much what we have learned, it's what we have created. And we have created case law specific to diversity visas during these new policies implemented by the State Department under the guise of COVID-19. So it's not about what we have learned, but what we have created. And we have created this case law specifically pertaining to this, and this will make the lawsuits move quicker because judges don't have to analyze these novel issues anymore, because at least 5 courts have issued preliminary injunctions against the government related to COVID-19 policies. So judges are no longer analyzing this issue on a blank slate. There's case law specifically pertaining to this, and it makes the judge's job much easier when he can look at what another judge does. He doesn't have to do as much homework when you can copy it.
Mm-hmm. So Julia Lavernock watched, as a Ray versus Biden plaintiff, who watched the chat with Charlie today, the guy that writes the visa bulletin, and she noticed that during the Q&A, he mentioned that the reason that all the case numbers were made current were to enable those to have an interview who sent their documents earliest. Does that mean only people with checked civil documents will be invited to interview and no other documents checked? I don't know what that means yet. I would not come to that conclusion. What you're saying in your question is that the State Department has complete control over how this is going to play out. We don't file lawsuits, so the State Department continues to have complete control. We are taking a little bit of control here by bringing the court into this process. Okay, so I wouldn't assume that they're going to get away with that if that was their plan.
That's right. We bring a lawsuit so we can be the captains of the ship. So I like to, after we win a lawsuit, I like to send an email to my team and tell them that we're the captain of the ship now. So we take over. So I have a question here. Should I enter a lawsuit if my documents are okay? I'm waiting for the email to schedule me for an interview, but the U.S. Embassy in Colombia isn't processing the diversity visas. What's interesting about our lawsuits is that we handle consular processing. We have consular processing teams. And if your particular embassy is not adjudicating visas, we may be able to transfer that and get you a visa interview. I think this was instrumental for a lot of our Mohammed and Fangjong clients in getting them their visas issued, because we were able to transfer them to different embassies that were processing the cases. I think a lot of European visa applicants were able to get their visas applicants transferred to Croatia, which was processing cases at a very high rate, and they were able to get their visas interviewed. So yes, I would suggest that you join the lawsuit, because we offer, in addition to a lawsuit, assistance in consular processing, which may be the difference for you. And it's I think it's for the value, it's probably unmatched by attorneys handling these types of cases.
I agree. This is related to Yusuf's question, actually. Yusuf asked, if I participated in the new lawsuit and were successful, would the location of my interview be transferred automatically to another country? I am from Iraq. Okay, so Yusuf's in this situation where the consulate in his country is closed. It's been closed for over a year. And the neighboring countries are not as cooperative as you would expect that they would be with this situation. And I think, is it Beirut that they're scheduled, that they're supposed to go to? The consulates, they have a problem when they close an embassy. Sometimes they send them to an embassy that's not prepared to take them. So here's the answer to the question. It's not going to be automatic, but we're going to work for you. If you are our client, we're going to work to transfer your case to where you can get the interview. We should keep a roster somewhere on how many cases we transferred, especially Mohammed and Fangjong. We transferred some of those more than once. The thing is, we have a lot better leverage to transfer a case once we have a court order. It's difficult to transfer a case before you have a court order if it's already assigned to a consulate. If it's still at the KCC, it's a little bit easier. So if you're I'm sorry, I'm talking about DVs for that. If you're a DV and your case is still at KCC and you want to transfer the consulate, you send an email to KCC, and 12 to 14 days later, you may get a response where they transferred your case. We have a lot of Iranians that are assigned to Ankara that are doing that right now and transferring to Yerevan or Abu Dhabi, and I think that may be a wise move.
Right.
We also have a lot of people in Moscow transferring to Georgia or consulates that they can get to, and that's also a wise move.
I agree. We have a question here from Dennis. Thanks, Curtis. Attorney Rafael, for your help. My question is, how will the upcoming lawsuit benefit high case number selectees? For example, 2021, Africa, 82,000. I think we can look to Mohammed and Fangjong for results for high number cases. I think Curtis and I set some records there for the highest numbers ever issued. So it can benefit you. It's not guaranteed that it will benefit you, but we're going to, it is in your interest to try to use everything you can to get your visa interview scheduled, because you are a high number and you need that.
Clint asked a great question. What are some ways we can advocate for DV 2020 selectees? Is it helpful to email senators? It doesn't hurt, but I would say the best advocacy for DV 2020 before Congress comes this way. Your U.S. citizen and lawful permanent resident friends and family that are in this country have legislators that represent them, members of Congress and senators. If they not only email, but call and go to the office and say, I want to talk to my congressman or senator about, well, I don't know because of COVID if they let you go to the office, but phone calls, and those are the people with the best chance of changing the mind or influencing a member of Congress. The individual DV selectees that are located in a foreign country, not as much influence over our members of Congress.
That's right. I have a question here from Hamad Husseini. What can be done to pressure the KCC and embassies to conduct a 2021 diversity interview? You sue them. Sue them. Take them to court to answer some questions before a judge. That's what we're going to do. And I suggest if you want to put pressure on it, you join the ship. Get on the boat, because this boat's going to leave, and we're going to go and we're going to put as much pressure on them as we can.
As long as we're here, nobody panic. The boat is not going to leave tomorrow. If you sign up for the wait list, We will let you know on May 1st when the vote is going to leave. I think it's going to leave around the week of June 6th. That's when we will file the case. But you're going to need to be on it before the end of May. Like the end of May, we're not going to take any clients in June after. And so the people that sign up first, we're going to have the advantage of working with their facts to make the most compelling relief. So I always appreciate the people that sign up first.
That's right. And if you sign up early, this is the benefit of signing up early. If there is a change in the circumstances, we will be able to help you earlier. Our help as early as possible benefits you because you're getting our help before anybody else gets our help, and we'll be able to navigate you as circumstances change.
Leilana asked if she can enter the lawsuit. She's waiting for the email about her interview. I think she's DV 2021 and the U.S. Embassy is Colombia. Yes, you should sign up for the wait list and we'll notify you on May 1st. Sana asked, did Judge Chin give any attention to IR5? I think that Rafael answered that.
Yes, I have that question.
Right. What's interesting is I think amongst our Jacob family plaintiffs, some of the IR5s are getting interviewed now because of their weird category prioritization scheme that they've made up. You know what I'm saying? This isn't law. They're just like, oh, immediate relatives of U.S. citizens, they should get priority over these other categories. So, anyway.
So I have a question here. It says, Islamabad Embassy is inviting spouses of United States citizens for interview while not inviting any F2A spouses. Would you do something for us? I'm a Jacob V. Biden plaintiff. We're going to address this issue. The F2A, the family preference category, and the pace of adjudication when compared to United States citizens is going to be the center of attention at the next hearing. What do we know so far? I'm looking here at the Pakistan immigrant visa issuance by foreign state of chargeability. This doesn't necessarily mean that all of these individuals were adjudicated in Islamabad, but it's a pretty good indicator. Then we know that for Pakistanis, 41 F41s were issued, 7 F3s, 1 F2B, 8 F1, and 30 FX, which is likely F2As. So they are adjudicating some, but it's nowhere near the pace of adjudication. I discussed a little bit earlier about whether this would be 221G refusal holdovers that were just simply adjudicated and doesn't accurately reflect the pace of adjudication. And these are issues that are going to be brought before Judge Chen at the next hearing. So we're on top of it, we're focusing on it, and we're hearing what you guys are saying about the pace of adjudication for F2As and other family preference categories at embassies, not only at Islamabad, but around the world.
For people that are Project Voyager or Mohammed Vong John Kennedy, DV 2020, that are asking about our lobbying efforts, I have an update on that, and we will send it to you through our MailChimp email updates. Okay. Depeche says, I'm a DV 2021 lottery winner from Nepal, currently residing in Norway. That's a unique situation, Depeche. And my visa interview post is Stockholm. My document is all approved and my case number current, but currently the U.S. Embassy in Stockholm is not processing at all. Should I participate in the upcoming lawsuit to help? Yes. The answer is yes. Question 2, if we participate, can we aspect the outcome of lawsuits within this fiscal year, or may it take longer? Our goal is within this fiscal year. Our goal is to get the visas as soon as possible, but it may take longer. Okay.
Okay, got a question here from a persistent question asker. Can you comment about the actions of Tashkent at the actions of the embassy in Tashkent regarding the tax transcripts? Consular officers can make specific requests of documents. They've requested that those tax transcripts be sent directly to the embassy, and that's what we need to do. So you need to be patient. You sometimes, it's easier to just do what the consular officer asks than fighting them on it. They have a basis for asking for it. They've requested it. So the best thing to do there is to do what they're doing, do what they're asking as quickly as possible, and this will lead to the adjudication of the visa much quickly. So just do what they're doing. I understand it's a little frustrating, causes a little bit of delay in your case, but at least they're working on it. At least you've gotten an interview and case is moving forward. It may not be what you want to hear, but
yeah, a footnote to that, if you want to know more about what the Tashkent issue, our joint status report, the last one we filed in Jacob, go to my website, go to Jacob versus Biden, and look at the last joint status report, and we've explained to the judge a couple cases at Tashkent on what's happening where they're requesting information that they don't typically request. Okay, so we have brought that to the judge's attention, that specific consulate is doing some unique requests.
James asks here, in case Jacob diversity visa plaintiffs do not get relief from Judge Chen, what's your plan for us since we can't join the upcoming lawsuit? We'd have to wait for the order from Judge Chen to come up with a plan of action. We can't come up with a plan before we see that order, what exactly he says in that order. But if you're a Jacob diversity visa applicant, you're sitting pretty good. He's put on the record that he is open to providing relief, so I wouldn't worry about joining a new lawsuit. Jacob is going quite well for diversity visas. He's already said that he's open to providing relief because of the statutory deadline. So why worry about joining a new lawsuit when your lawsuit is going relatively well? Lama says, my case is not current till now. Can I join your upcoming lawsuit plaintiffs? Yes, you can. The short answer is we have claims that says that the adjudication of the Field Affairs Manual, which is a State Department policy, doesn't say you should be scheduled for a diversity visa interview at the time your visa becomes current. That's not what it says. It says that you should be scheduled before you become current, because the State Department understands there is a finite, a limited, short amount of time to adjudicate diversity visa applicants. So they want to get, their policy is to schedule people before their visa becomes current, right? In the FAM, it says visas should be scheduled before they become current, right? So before you become current, you're scheduled. At the time of your interview, you become current. You should be current at that time, and you should be scheduled. So yes, you should join us on our lawsuit, even if you just became current, because they've already delayed your case unreasonably.
Richard from Ghana says, can he join the case because KCC isn't working on his file? Richard, please sign up for the wait list. We'll have an announcement on May 1st that will explain everything, but we would like to have you on the case, yes. Philip from France says, my case is current since January and all my documents have been approved by KCC in March. That means Philip is DV 2021. A lot of you aren't identifying your categories and you're making us figure it out in the context of the question, and that's hard. But DV 2021, approved by KCC in March. Miracle, yes, congratulations. No interview yet. Is it interesting for me to join the new lawsuit? What can I expect? Philip, yes, I would encourage you to join the new lawsuit. We had plaintiffs from the Mohammed case from France that are now in the US. I know that for a fact. So do you have one, Rafael, or do you want me to keep going?
Yeah, I got one. Simo asks, if we pay the initial $500 to join the lawsuit, when will we have to pay the rest? Is it right away after we arrive in the United States? Yes, the remaining balance is due at the time of arrival. So that's what the retainer agreement will say.
Zareen asked, why did Judge Chen issue PI relief to Young, but not willing to do the same for Jacob plaintiffs yet? Good question, Zareen. Thank you for asking it, because I get this question a lot. When Judge Chen issued the PI relief to the Young plaintiffs in December, 2 months after they filed their case, there was an unlawful proclamation that they were being subjected to, PP 10014. Around the third week of February, that proclamation disappeared, partly as a result of this Jacob litigation where Judge Chin moved a hearing saying, we're going to give you until March 4th to solve this problem, Mr. Government. But anyway, so now we have a difference. Jacob is a different case than Young, because we no longer have the proclamation itself as a barrier. All we have as a barrier are the collateral consequences and the lingering impacts of the implementation, unlawful implementation of PP 10014. All the things the State Department did besides the text of 10014 to basically end immigration, what Judge Chin calls the no visa policy. So what we're waiting on, and I think May 20th, there's going to be clarity on this, is the no visa policy in effect or not? And it's not a matter of what Ms. Robinson says or what we say. It's really a matter of what those numbers show. So if visas are not being issued, the no visa policy is still in effect.
That's right. And if it's still in effect, yeah, the numbers don't lie. This is going to be very important. Let's see what the numbers say. I think we'll probably do a Facebook Live or discuss with the Jacob plaintiffs the numbers when they come out, and we'll interpret what those numbers mean and start to discuss our plan of attack then. Let me see. I think I answered this question. Go right ahead, Chris. I've answered this question plenty of times.
Okay. Thomas says, for the new lawsuit for DV 2021, if I'm in another lawsuit not from your firm, would I still be eligible to join yours? Thomas, you can't bring the same cause of action in two different lawsuits. If you were in enunciado, the answer is yes, because that lawsuit did not bring many causes of action. But if you're in, like, say, Go, I think that it has a mandamus and unreasonable delay claim, so you couldn't. There are some other lawsuits out there by Ms. Glazer that I haven't seen the complaint, so I don't know what the causes of action are, but I'm willing to bet that they have mandamus and unreasonable delay claims, and you can't bring those claims in two different lawsuits. So the answer is probably no. Okay.
And on that point, if you want to join our lawsuit and you're thinking about joining another lawsuit before joining, you have to decide now which lawsuit you want to join. I suggest joining ours. I think we're great attorneys with a proven record of success. So don't jeopardize your chance of joining our lawsuit by joining another lawsuit before it's time.
But there's, I mean, you can voluntarily dismiss your claims in the first case all the way up to the point where the government answers the complaint. So that's right. Generally speaking. So if you want to switch, if you want to get off that boat, get on this boat, you can. Just can't be on two boats at the same time. It doesn't work.
That's right. And it may be a waste of your money to get on two boats if you want to do that too.
Yeah.
Should
DV, I love this question. Should DV 2020 prepare documents like passport and police certificate earlier before the final judgment is made? Absolutely. And the reason is there's only 9,095 visas, and there's a good chance that it's going to be competitive in getting those. Of course, the consulates are not working that fast, but you don't want to be responsible for your own delay. So if there's anything that you can do to take off the table, take it off the table and make it to where that's no longer a problem for you. You already have your police certificate. And so for people that are just tuning in to this issue, police certificates generally are only good for 1 year. So if yours is more than a year old, it's worthless. Your passport has to have 6 months of validity the day your visa is issued. So if you have 5 months now or 6 months now, that passport is not going to be good to be issued a U.S. visa. So get it renewed now while you have time to do that, because you don't want to do that when you don't have time.
That's right. And there's no, police certificates are good for a year. So if your old police certificate was issued more than a year ago, you were going to have to get that police certificate reissued. And I don't think there's going to be any duplicate work for you because it is good for a year and it's not tied to the validity of the period of the visa. So there's no harm in getting it done now. And there's only a benefit that you won't have to do it at the time Judge Mehta issues an order.
Great. I see where CC asked, can IR5 join the lawsuit? Not sure which lawsuit you mean. Could mean the next one we're going to file. You can't join an existing lawsuit. However, if you're IR5 or you're F2A and you missed the boat for Young or Jacob and you want to sue the government, we will do a solo case. We offer those. We charge $5,000 for a solo mandamus lawsuit. And email me directly about that, and I can talk to you about it. There's also a link on our website called Mandamus where we talk about that. Jacob plaintiffs, do not ask me if you could file a mandamus also, because you already have a mandamus and you can't file a mandamus in 2 different cases. There's advantages to solo, there's advantages to multi-participant. The Jacob multi-participant case, if you're already on that, you're in a good position because you have a good judge that cares about you, and a pending motion for preliminary injunction that could get a decision soon. You don't want to start over.
Right. For F2A, should we wait to upload new PCC until interview has been scheduled, or do we upload the SEAC now? Worried that uploading additional docs now might push documentary qualification dates back. This is a valid concern. If you uploaded it and have already been determined documentarily qualified, I wouldn't worry about it and would only worry about it once you've been scheduled for the interview. For family preference categories, this is a different story for diversity visas. They have to be ready to go immediately.
Ashfaq asks, I'm a Jacob v. Biden plaintiff. Will the Jacob case get more hearing dates, or we will get a decision on the 20th? The only way that we would not get more hearing dates is if he just dismissed the case. I don't anticipate that happening. So I believe that there will be more hearing dates. There will be more status conferences, more hearings on motions. What's important to understand about a lawsuit, it's not just the hearing, it's the papers. And that's why on my website, curtismorrisonlaw.com, you go there, we have the docket entries, the papers, so you can see the things that we're arguing about, where we've typed the words on paper and the government's argued back with papers. That's really the stronger part of where the decisions are made. Oral arguments just settle the questions that remain in the judge's mind.
Great. So I have a question from Pakhomenko. Good day, I'm a Jacob plaintiff. Moscow's still not inviting for interviews. We want to transfer the case to an embassy that's working. What can we do in this situation? You can contact the paralegal who has been working on your case, who has introduced themselves to you, and tell them what you want to do, and they'll assist you in trying to get that done. So contact them directly. You don't have to CC or include Curtis and I on that email. The paralegals will communicate with us directly on what they need to do. We've been talking to them about what to do in this situation because we knew this may be an avenue that we could provide relief to Jacob plaintiffs. So contact them directly and they'll be able to assist you. Just email them. That's a great thing about our office. You have consular processing teams to assist you with this sort of stuff. I mean, it's a great bonus in joining our lawsuits.
Yes. Also, when you contact the team member that's working with your file, give them any evidence or information about your tie to the country where you want to transfer your file. So if you're a citizen of another country, attach that. Or because if there's a compelling reason why, like you're located in the other country other than Russia, that's good information. Okay, so be sure to include that also.
James, I've answered your question 3 times. In case Jacob diversity visas plaintiffs don't get relief in the Judge Chen, what's your plan? We can't have a plan for what to do until we see that order. It's tied to the order Judge Chen gives. So we have to wait for that order to give you a plan, all right? No need to ask that question again. I have another question here. Since the KCC is taking so long to process documents, can't the interview just be scheduled and the documents be processed during the interview at the embassy? That's what happened in our Mohammed and Fanjang and Kennedy cases. They decided we're not going to process it at the KCC. We're just going to forward these files to the embassies, and people have to show up with all of their documents ready for the case to be issued, or they're going to be refused. So it is a possibility if we get a court order. And it may be a solution for KCC to just start doing that to get as many visas issued if we bring lawsuit and put pressure on them.
Marco asked, I don't know if you answered this, do you expect Egypt to be current in the upcoming visa bulletin for DV 2021? Marco, I was not able to listen to Charlie, but I heard and saw on Twitter that he said that the answer is yes, that everybody will be current. Is that true, Rafael? Did you listen to him?
That is. If you go to my Twitter page, I screen grabbed the clip in which Charlie states that he anticipates all countries will be current in the July visa bulletin. You can go and listen.
So if you're in Egypt, or right?
Egypt, Iran. No, that's right. Big news for the Nepalese, the Egyptians, and the Iranians. So they'll be in the same boat as everybody else come July.
3 of my favorite countries, as you can see from my clocks.
Big diversity visa countries, Iran, Egypt, and Nepal.
Yeah.
I have a question here. I'm on the wait list for your next litigation. I'm a South American region assigned to Bogota. I'm documentally ready since last September and will be current in July. I am in Venezuela presently and have a valid B1, B2 visa. What's my best chance? Wait here, travel, and adjustment of status. This is a tricky question, and you should contact us directly to answer this question about adjustment of statuses, because there's some ways that you can ruin your chance of getting your diversity visa adjudicated through adjustment of status if it's not done correctly. Contact us directly to answer that question, and we'll be happy to help you and tell you what the law states, and you can make a decision.
Farouk asked a question. Last year I came from China. I got my no criminal records check after I came back, but it's been 6 months. Now it's almost 1 year I'm in the country. Do I need to get a new criminal record check from China even if I didn't go? If you have not been back to China, you do not need a new criminal records check. I'm not sure what state you're in. I think Belarus or Poland. I can't tell. You do need a new criminal record check from the country you're in, but you do not need a new one from the country that you were in a long time ago that you haven't been back to since.
Ahmed has a question here. We received an email from somebody from Rafael's office, including someone I think is an attorney will be in contacting with KCC for us. Please explain. It's likely not an attorney that has contacted you. It's one of our paralegals, just to be clear about that, who's working under our direction. They are assisting everybody, all of our clients, with consular processing. What they're doing now, or if you're a Jacob client, they're providing my G28, which was my notice of appearance, which basically is your permission to the State Department for my office to speak on your behalf. So that's what's happening. They're submitting our G28. So if we can begin the process of getting your visa adjudication done, and whether that's transferring cases or submitting documents or these types of things.
For the next case, Simo asked, she knows the initial, or he or she knows that the initial fee for the next DV 2021 case will be $500. When will the next payment, the final payment, be due? That will be after you enter the U.S. We basically break it up into 2 parts: initial payment and then the final payment when you're doing the U.S. Also, we're not monsters. If you show up in the U.S. and you're broke, we're going to give you a couple months, 3 months to get that done.
Ferdinand Taku asks why the embassies around the world are not working with diversity visas, and now that the regions are current too, if they only schedule 12 interviews in a month, if they still work like this, diversity 2020 will not be finished for the next 2 years. I think 2 years is a low estimate of when they'll be finished if they can only issue 17 a month. But yeah, this is why we're going to court. because it's unacceptable and it's unreasonable and it's against the law.
Is attorney Ms. Robinson doing this just to win the case?
Probably. That's her goal. She's representing the interests of her clients, and she's doing everything she does is to win the case. Yeah,
and to be clear, she's watching this video. Hello, Kimberly, because she's actually a good attorney, advocating for her client. Unfortunately, I don't think she realizes her client is no longer President Trump.
And Kimberly, I'm a little jealous you put Curtis's tweets in the brief. If I want some PR too, put my tweets in there too.
Rafael's sending some really good tweets, Kimberly. Please put those in there.
I've never seen the government insert tweets like that for an attorney. It's a chilling effect. I think it was pretty bad precedent. But
well, I haven't chilled. So it's not working. It doesn't. It hasn't had the chilling effect.
Yeah, so, we don't back down for anybody, huh?
Right. Okay. This is a good question. Anton asked, I'm a DV 2021 plaintiff in the Jacob case, but I've also joined another lawsuit challenging the Department of State actions regarding the delay of processing visas in a specific problematic consulate. Do you think it may cause any problem? Well, Anton, as I've mentioned, Kimberly is watching, so I probably shouldn't have read that out loud. I didn't realize what it was going to say until I got through it. It could cause a problem, but not for Jacob. It will cause a problem for the second filed case. If it has the same cause of action, if it has a mandamus or Administrative Procedures Act claim under 706, you can't bring the same cause of action in two different cases. But if it's a separate cause of action, different facts, then you'll be fine. I hate that you're bringing it to the government's attention that you did that and that I credit. I apologize.
Paul, what are your plans for Jacob DV 2021 against Kimberly on the 20th? We're not going to discuss that here. We don't want to tip our hat to the government and give them an opportunity to prepare for those questions. So if you have a question about that, reach out to your team member personally and they can communicate what we plan to do. So I have another question. Dear Curtis, DV 2021 plaintiff in Jacob case, 17,000 plus case number, current MA, sent paperwork to KCC, but no reply, have B1, B2 business in US. Contact your team member about that question and we'll be able to provide you with some assistance. We don't want to discuss adjustment of statuses and personal questions about your case in this forum. There's no confidentiality here, and it's better if we answer your questions personally. So just email your team member and they'll give you an answer that we give them.
How do I make sure, Marcia asked, how do I make sure that I'm in the waiting list for your new lawsuit? When you sign up and you push submit, it says, I think it says you submitted. You did it. And you will know if you don't receive an email from us by May 2nd, then you can call me or something then. You can email us then. But we will make the announcement for everybody on the wait list on May 1st. If you filled out everything and you click submit, we have it.
That's right. Just follow us on Twitter. We're going to be putting information about how to join the lawsuit, even for individuals that aren't on the wait list. So there's going to be, even if that for whatever reason, if you made a mistake and didn't get it confirmed, it is not, joining the lawsuit isn't dependent on being on the wait list. It's good for us to communicate to people and for people who are very interested in the case to get up-to-date information as quickly as possible. That's why we created the wait list. But if you made a mistake there, don't stress out too much. You'll have an opportunity to join the case.
I'm just getting a whole bunch of likes all of a sudden. I don't know if they were stuck somewhere, but I'm happy. Thank you for all the likes.
Here comes the likes.
Yeah, even more of them. They're so sweet. I wish we could like back. Can we do that? Sonia, how do you like back? I'm just going to start reading. Hold on.
Yeah, I have a question from Zaheen. Can we use the February, March, and next April visa bulletin to show the no visa policy being practices? Yes, we can. And we have. I think we've submitted the visa issuance statistics in the JACOB PI. So we've already done that. And we're going to get more up-to-date numbers at the next hearing, or in the next week, actually.
Right. Helen asked a question that I wish we were in the room with people in DC at the State Department so we could ask this question too. Since KCC is taking so long to process documents, can't the interview be scheduled and the documents be processed during the interview at the embassy? I think maybe Britt Simon in his video a couple days ago proposed this. I don't have a problem with that, but that's just like a common idea. That's not their policy. That's not the way they like to say they do things, but they can do it that way if they wanted to. So I appreciate you putting that out there again, because there's no reason why consulates can't schedule an interview even before DQ, because they'll be in front of you and you could give them the documents that they're looking for.
Cecilia is a JACOB plaintiff. IR5 in Juarez needs her mother's scheduled interview rescheduled. Contact your team member that's emailed you. They'll assist you in any way they can.
Hussein asks, will DV 2020 need to take a medical test earlier before the final judgment is made, or they will be notified to submit that once their applications have been processed? Two things. First, I don't think you can. There's only like a couple consulates of over 130, I think, that allow people to get a medical exam without permission from the consulate. And I think you're really going to have to wait until final judgment before you try to do that. At the same time, once there is final judgment, I think the people that are proactive in trying to get that, proactive means not emailing me. Proactive means contacting the medical examiner himself and saying, what is it I need to do to get you to give me a medical exam? I think that's the people that did that in September of 2020 benefited. So do be proactive in trying to get your medical exam. Not now, though. Wait until after final judgment, because you don't know when it's going to be. I mean, we hope it's in May at this point.
Right, and with the medical examinations, you know, although they're approved by the State Department, they don't work for the State Department. They're their own separate entity. They certainly don't answer to attorneys, and judges' orders here in the United States don't really mean anything to them. So working with them and giving them what they are asking for is probably the best course of action.
Zaheen says, can't we use the February, March, and next April visa bulletin to further show how no visa policy is being practiced in almost all embassies, still where citizens are still getting more than 95% of the interviews after the ban got lifted? I assume that Zaheen's a plaintiff in JACOB, or
yes, and I've answered the question. Yeah, we included the visa issuance statistics in our JACOB PI, so we've already moved past that, and the judge wants to see up-to-date numbers, and we're going to get that next week. So we've already done it. We're a step ahead of you. We're moving forward on after the revocation of PP 10014 is really the issue before the court and the next JACOB hearing.
Sorry, I missed that.
It's okay. I think we caught up to most of the questions here and getting duplicates.
I'm showing 390. I'm not sure about that you were caught up. We are getting a lot of duplicates, though. Okay, can we get our visas if Gomez won? We are DV 2020 who refused their visas because of 9645. 9645 should not be a barrier to you being issued a visa if you're DV 2020. If you're our client, either through Mohammed Fong John Kennedy or Project Voyager, we will do everything we can to make sure you get your interview after the final judgment, even if you were previously refused under 9645.
I have a case here, a question here from Majid. My case was expedited like a month ago. Haven't received an interview yet from Islamabad. Any idea how long I have to wait? We do not have any idea. This is why we're pressing the issue in federal courts, because the processing of visas has not been going orderly and has not been going as quickly as the law states it has to go. This is an unreasonable delay. So unfortunately, we don't have an idea of how long you have to wait. Islamabad isn't interviewing people. Everybody knows that. It's unfortunate.
Great question from Uzbekistan. Tashkent isn't issuing DV visas, so should a DV 2021 try to change their interview location to a neighboring country, or need to wait to participate in the next lawsuit? We would recommend both. Do participate in the next lawsuit by signing up on the wait list now, but also if there is an adjoining country that you could transfer to, contact KCC. Be patient for 12 to 14 days, because that's how far they are behind in inquiries, and request that they transfer your file to that other consulate. But do your homework first. That's not a unique situation that Tashkent is not issuing visas to DVs. That's the majority of consulates in the world. So transferring could just create an inconvenience for you if you transfer to another consulate that's not issuing visas, for instance.
That's right.
So just be mindful of that.
Yeah, I think for diversity visas, if you know your embassy is closed to all processing of visas, it's probably a good bet to change your embassy. But if it's just diversity visas specifically, I don't know if that's a good reason to change just yet. So I have a question from Alfie. Please give us an answer on the question for individuals who have large case numbers, will they have a chance in your lawsuit? Yes, there's precedent for that in the Mohammed, Fanjong, and Kennedy cases for large case numbers. So I would suggest, I would state confidently that there is a chance. I have a question here from Hamza. If we won on Kennedy, do we need to send documents to KCC, or will you be in charge of all procedures since we filed the form? Casey, we got to really wait for the judge's order on what's going to happen and see how they're implementing it. It's best if we all work together. If you send those documents over, if we send those documents over, we start working with the embassies directly. It's going to be an intense process, to say the least. So we're going to have to all work together. There's no harm in you sending those documents over and us sending those documents over as well.
I see a second question from CC, follow up to the first one. Turns out she's a JCAT plaintiff, Ir5, parents of US citizens at Consulate in Juarez, not scheduling interviews, and mom needs interview rescheduled. Work with the team member that we've assigned to you on that, and they will do what they can to expedite given the documentary evidence that you provide. But understand, the best chance of us getting interviews for all of our JCAT plaintiffs is when we get an order, preliminary injunctive relief from the judge, and we would not anticipate that happening before May 20th. So be patient, and once we get an order, then we have leverage. Leverage is important to get the interview scheduled. That's really our best hope.
If I'm not on the waiting list for the new DV-21, can I join the lawsuit? Answer is yes. We just provided you the link to the wait list, so it may be worthwhile for you to just do that right now, and then you don't have to worry about it, but you will be eligible to join the new lawsuit. I have another question here from Hussein. The Egyptian police certificate is valid for only 3 months from the date of issuance. Do I need to get a new one? I don't know when you got it, and there's no context to the question, so I can't give you an answer. But your police certificate has to be valid on the day of the issuance of your visa. So I think understanding that, you can make the determination of whether you need a new one or not. So if your case is perhaps going into administrative processing and there's only a week left on the validity period, I would suggest getting a new one and submitting it to the embassy.
Ashraf asked another interesting question. DV 2021 selectee, my wife is a lawful permanent resident and my kid is a U.S. citizen. They both reside in the States. Any way to convince embassy to schedule an appointment? Current DQ, Abu Dhabi embassy. I don't think those factors are going to give you an advantage right now. Under the former framework, they would have, because you would not have been subject. No, you're a green card holder. She's a green card. Under 10014, spouses of U.S. citizens were exempt, but spouses of green card holders weren't. So actually, no, you wouldn't have had an advantage then either. And there's no advantage in immigration processing to have a child that's a U.S. citizen. There's nothing stopping from that child from coming. The reason is the way the government looks at it, there's nothing stopping that child from coming and going, so their interests are not impacted. Although that's not logical, because the children are not hopping countries by themselves. So actually, you can try, but I don't think it's going to work.
Can you help? I have a question here. Can you help expedite documentarily qualified F2A if we hired you? Yes, we can. We offer a tiered approach to this. We help with consular processing, and if those consular processing efforts, such as expedites, don't work out, for another fee, that we give you a discounted rate on a mandamus action. Go to Curtis's website, look for the mandamus section, and you can review there, and reach out to us if you like what you see.
Hamza says, if we went on Kennedy, which is consolidated with Gomez, Fangjong, Mohammed, and Aker, do we need to send documents to KCC, or you will be in charge of all procedures since we filed the form? Thank you, both of you. Thanks for the question, Hamza. That's a great question. If you feel confident in sending the documents yourself, and you could do them before we can, we will give you support if you're patient. Okay. If you feel confident in the procedure, do it yourself. Okay. If there's a question, then come to us.
I have a question here from, sorry, I just lost the question, from Mustafa. I want to ask you, why don't you see with the other attorneys to find a solution for the 9,900 visas for DV 2020 winners? We have attempted to work with the government attorneys on this. We've worked with some of our co-counsel on this. We couldn't come to an agreement on what the relief should be, but we've already tried it. So that's the answer to the question, is that we've already tried to do that with both the counsel with the other cases, Gomez and Aker, and we've also tried to reach out to the government. We're not unable to come to an agreement on what that processing would look like and the number of visas that will be issued post deadline. I haven't. And
I just want to add to that, if that doesn't feel right, you're right. It shouldn't. The fact that the Biden administration is fighting hard to defend Trump's most unlawful and damaging actions is crazy to me. Like, why did we vote for him? What's the point of changing the president if the new one is just going to defend the worst actions of the previous one? So we are with you, and we understand why that does not make sense that they're still fighting.
Right. And it's weird, because does Biden agree that it was lawful? Does he think the actions taken by Trump were in accordance with the law? Because he on the campaign trail, he said that he was a rogue actor and we couldn't trust him and he was doing things that were unlawful. But suddenly, now that he has a seat at the table of power, he's agreeing with those decisions. It doesn't match up with his rhetoric that he was running on. So I have a question here from Nikita. I'm a rape plaintiff, and the DV diversity visas are not adjudicated in a physical year for us. How are the chances to get DV 2020 visas reserved after the deadline? I think the chances are good. Our judge, Judge Chutkin, has done that before for DV 2017 Muslim ban visa applicants. She reserved visas. Unfortunately, she waited too late, and she was only able to reserve a small amount of visas for those individuals. So I would say that she has precedent of reserving visas if they were not able to adjudicate those visas before the statutory deadline. But to get a real sense of whether that's a possibility, we're going to have to wait for the hearing date. When we get our case before her, and when I'm arguing the case before her, we'll get a feel of whether she wants to do that or not. Our goal, though, is not to have Judge Chutkin reserve visas. We want her to get you processed before the statutory deadline. That's just a way easier way to handle it, because you don't have to wait as long, and there's lessens the risk of losing the case, which I don't think is going to happen. But so our goal is to get you adjudicated before the statutory deadline.
Simo asks, do you mean you have a discount for DQ DV21 selectees who are in countries that process DV cases? No, Simo, I didn't mean that. If I said that or Rafael said that, that's not what we meant. This question gets asked a lot, but I think it's because people jump in and out. Who has the DVs with large case numbers? Will they have a chance in your new lawsuit? Yes, our next DV 2021 lawsuit will be open to all, regardless of case numbers. And the reason is pursuant to what we've heard from Charlie today, everyone's going to have a current number. So the case number itself is no longer the barrier that anybody faces.
Mr. Patel has a question. Can you help expedite a documentarily qualified F4 India case? We can help with that. We know that the embassy in Mumbai isn't very agreeable in expedite requests, and even when they do approve an expedite request, it doesn't necessarily translate into the scheduling of an interview. But like I said before, we offered a tiered approach to this that increases the intensity of our efforts as the case progresses. So go to Curtis's websites, research what our mandamus lawsuits are, and then reach out to us directly if you're not part of a lawsuit already, and we can discuss how we can help you.
How are the chances to get visa for DV 2021, like EU 21K? I don't know how to answer that question, actually. I mean, sometimes people are asking me, what is the calculation today? And I'm like, how would I calculate that? I don't know. All I know is in 1990, Congress told the State Department that they were going to use their best efforts to issue 55,000 diversity visa lottery visas a year. So there's a duty to do it, and we're going to court to see that they do it.
Okay, I have a question here from Becky. Hold on, I want to address this once again, Becky, because I'm getting a little frustrated with the spreading of misinformation here. Seems like your question disappeared.
Oh, it's still there. What can you say about family-based visas in the Jacob v. Biden case?
No, there was another question here.
Okay, and by the way, I've ordered the transcript from the last Jacob hearing, and I put it on a 3-week, so we should have that in a little bit more than 2 weeks, and I'll share that publicly like I share all of our transcripts.
I think the question, Becky, you asked is, what can we do for individuals who are Jacob plaintiffs? And then there was an insinuation that we haven't helped you. I just don't understand that. If you look at the docket, there's, what number are we at in the Jacob docket? How many entries are we at?
Is it 227 or something? No,
yeah,
no, that's another case. That's the other case. Give me a second, I'll check. So
this issue that individuals are saying that we're not concerned about family-based categories is just simply not true. It borders by some individuals who I think are purposefully lying and thinking that if they spread this lie, that somehow we will advocate on them more than we are. We cannot, because we are zealously advocating for you, your cases. Not only are we advocating in the court of law, We are advocating directly to the embassies. We have consular teams that are submitting expedite requests for every single Jacob plaintiff family base. Let me repeat that. We have put our teams together to submit expedite requests for every single family preference category visa applicant that's on Jacob. So this idea that we're not advocating on your behalf is simply a lie. It's simply not true. I don't want, and it's getting frustrating dealing with that, and I'm starting to wonder if people are purposefully lying and thinking that that will help them, but it's not. It's just it's getting on my nerves.
Rafael, I get in the same place, but we got to remember also that everybody's going through some stress with some other stuff. I don't like to talk about COVID, but I realize that that is a big factor in a lot of people's lives right now. And so if you're going through some other stuff and you come off like you're angry with us, I understand. I understand.
It's one thing to be angry, though, but it's one thing to say that we haven't helped you when you have been contacted directly from teams, have expedite requests submitted on your behalf. So to be frustrated with the process is one thing, but to say that we haven't helped you, or we haven't done anything on your behalf, or we haven't mentioned a specific visa category or advocated before, it doesn't correlate with the facts. And it's not as though this case has just started. We've been in front of the judge several times, and we've come, and Curtis updates you more on a almost daily basis, I guess what, bi-weekly basis.
Very
we send
frequent basis.
Very frequent basis, explaining exactly what's going on. So yeah.
You're right. Shuza asked a question that we touched on earlier, but let's go specific to it. Could you kindly make sure to speak about Islamabad embassy and check how many visas they issued at the next hearing? Okay, no. And the reason is there's 130 consulates. Do you want us to talk about each embassy and how they're doing, or do you want us to talk about the legally relevant facts and law that get you the relief that you want and answer the judge's questions that the judge has? That's what we go to a hearing for, to answer the judge's questions in their mind, not to repeat the things that our plaintiffs want us to say that do not get their relief. And also, just so you know, Islamabad is bad at issuing visas right now, but it's not alone. That's basically most consulates. And you're right. The things that Ms. Robinson was saying in that hearing were not true. However, I'm careful not to think that she did that intentionally. It's very possible that the attorneys that work at the State Department that are advising her are misinforming her. And so she's repeating their misinformation. Doesn't make it right.
Right, but we'll have an opportunity to address that at the next hearing, right? That's why they have a hearing after the status updates, and we can respond to blatant misinformation if we come across that.
Mamoon has a F2A visa waiting for interview. Can he apply for a non-immigrant visa and file the 160, DS-160, and expedite request for NIV directly to the embassy? Will this affect your F2A visa? No, it will not have a negative effect on your F2A visa, but it will be probably wasting money. And the State Department does need money, though, so if you want to give them money, you can. It's just they're very unlikely to issue a non-immigrant visa to an immigrant applicant because you've already shown that you have immigrant intent, so you're going to have to overcome that burden.
Right.
Okay. Shuzo says she makes up stuff all the time. She is being misinformed.
We know.
Yeah, we do not disagree. So thank you all for the ones that stayed. Oh my gosh, there's like 130 people that stayed through the whole thing. Thank you so much for that. Unless, Rafael, do you see any other questions?
No, I just want to say I don't want to end on that note. I know that everybody's going through a hard time with everything, but let's put the truth out there. Let's say that let's talk about what's happened in actuality, and we have the transcripts, and we can discuss the transcripts with individuals that have issues with that. We could take specific portions of the transcript and talk about what's going on with that. But we are advocating for everybody.
hi.
It's passionate.
Yes, we are. Our whole team is.
Yeah.
I want this question. Impact team is filing a lawsuit. Which lawsuit has better chance of winning? Theirs or yours? Ours.
That's facts.
Okay. Or you could look at Annunziato case and see how that worked out. I mean, I'm just saying. Okay, I don't mind ending on that note. Are you okay?
I am. I'm good. Been a pleasure,
Okay.
guys. We'll be in touch very soon. We'll probably do another Q&A after we get the ball rolling on the new lawsuit.
Yep.
Talk to you guys soon.
Talk to you soon. Hi, this is Curtis Morrison. If you like this video, like and subscribe. Thank you.